The Ohio Revised Code provision that Leon had found and read 3 times deserves to be understood in the context of why the legislature had written it the way it had. Written it because that context makes the certified mail requirement something more than a procedural formality. Tax sales in Ohio, as in most states, are the mechanism by which the government recovers unpaid property taxes from properties whose owners have not paid them, and the mechanism necessarily involves the possibility of the owner losing the property if the delinquency is not resolved. The legislature, in creating this mechanism, had understood that the loss of a family's property to a tax sale was a significant consequence that should not occur without the owner having actual knowledge of the impending sale. The certified mail requirement was the legislature's specific answer to the question of how to ensure actual knowledge, because certified mail required the signature of the addressee or an authorized agent before the delivery was complete, which meant that a certified mail notice could not be delivered without someone who was accountable for receiving it actually signing for it. If the addressee was not at the address, certified mail was not delivered, and the undelivered status was recorded, and the undelivered status would prompt the procedure to seek the owner's actual location. Regular mail, by contrast, was delivered to the address without any signature requirement, and a regular mail delivery to an address did not confirm that the person the mail was addressed to had actually received it. It confirmed only that the mail had been placed in the mailbox at the address, which was what had happened with the Holthouse notices. They had been placed in the mailbox, August had taken them from the mailbox, and Leon had not seen them. The legislature had anticipated exactly this scenario in writing the certified mail requirement. Leon had found the anticipation in the statute. The finding had saved the farm. There are 2 kinds of legal stories about land and property in American farming history. The first kind is the story of the man who loses the land because the law works against him, because the foreclosure is legal and the sheriff's sale is legal and the eviction is legal and the law, as written and applied, says the land passes from the farmer to whoever holds the note. These stories are numerous in American agricultural history, and they are the stories that the men who farmed in the difficult decades understood as the risk that farming carried, the risk that the legal system's machinery would work against the farmer if the financial machinery had already worked against him. The second kind of story is rarer and less often told, which is the story of the man who discovers that the legal machinery has made its own error, that somewhere in the process by which the county or the bank or the creditor has moved to take the land, a specific procedural requirement has not been satisfied, and that the failure to satisfy the requirement is not a technicality in the dismissive sense, but a substantive protection that the law built into the process for exactly the reason that the protection is needed. The distinction between these 2 kinds of stories matters because it is easy to hear a story about a procedural defect in a legal proceeding and conclude that the outcome turned on something unimportant, on a technicality that should not have been decisive in a case where the underlying obligation was real. This conclusion is wrong about the nature of procedural requirements in property law, which exists not as arbitrary formalities, but as protections designed to ensure that the owner of a property has actual knowledge of a proceeding that will affect their ownership before the proceeding concludes. The certified mail requirement that Leon Holthouse found in the notice that August had kept in the drawer was not a technicality. It was the specific mechanism by which Ohio law ensured that a property owner had actual notice of a tax sale before the sale occurred, and the failure to use certified mail was not a minor oversight. It was the failure to provide the specific kind of notice that the law determined was necessary for the owner to have a real opportunity to respond. The letter from the Paulding County, Ohio Auditor's Office arrived at the wrong address in October of 1958. This is the central fact of everything that followed, the fact that the correct address was on file somewhere, and that the letter went somewhere else, and that the farm that had been in the Holthouse family since 1903 was sold at a tax delinquency sale in November of 1958, while the man who owned it was working the Mississippi River barges out of Baton Rouge, Louisiana, and did not know the letter had been sent, or the sale had been conducted, or that the place where he had grown up was no longer, by the county's accounting, the Holthouse family's connection to the Paulding County ground went back to Heinrich Holthouse's decision to buy the 80 acres in 1903. a decision made by a man who had come to Northwest Ohio from the German-speaking farming communities of Wisconsin in the late 1880s and who had worked other men's ground for 15 years before he had accumulated enough to buy his own. Heinrich had been the specific kind of immigrant farmer who understood that land ownership was the foundation everything else was built on, that the tenant's position was not a permanent position but a temporary one on the way to something more secure, and that the accumulation of the purchase price for a piece of ground, however long it took and however modest the piece of ground was the most important investment a farming family could make. He had farmed the 80 acres for 25 years, adding the 32 additional acres in 1921 when the adjacent land came available and when the farm's production had reached the level that made the addition affordable, and had handed the 112 acres to Leon's father Carl in 1928 with the same debt-free condition that the Hess farm in South Dakota and the other careful farming operations of that era's best practitioners had achieved through the same combination of consistent work and consistent restraint about what was borrowed and when. Carl had farmed through the Depression and the war years with the specific difficulty that every farming operation of that era experienced, but he had held the ground and had handed it to Leon in 1949 without the encumbrances that some of the neighbor operations had accumulated during those difficult decades. Leon had carried the farm through the early 1950s as long as he could and had left with the intention of returning, and the specific legal error of a county auditor's office that used regular mail where the statute required certified mail had nearly converted the intention into an impossibility. The man's name was Leon Holthouse. He was 41 years old in the fall of 1958, and he had been working the river since 1954, when the farm's income had been inadequate for the second consecutive year, and the operating loan from the Defiance County Bank had come due in a way that the farm's cash position could not manage. He had left the farm in the care of his neighbor, August Feuerstein, who was 63, and who had agreed to keep the fields from going to brush and to apply what income could be generated from the hayfields against the modest amount Leon still owed on the property, a note that had been small enough when it was taken and that had been reduced to something under $400 by the time Leon left. The farm itself was 112 acres in the northwest corner of Paulding County, in the flat black prairie soil country of northwest Ohio. The ground that had been tiled and drained in the early decades of the century and that was capable of producing good corn and soybeans and wheat in years when the management was consistent and the weather cooperated. Leon's grandfather Heinrich had bought the original 80 acres in 1903 and had added 32 acres in 1921, and the place had been in the family continuously since then, first under Heinrich, then under Leon's father Carl, who had farmed it from 1928 through his death in 1949, and then under Leon, who had tried to farm it through the difficult years of the early 1950s and had found the trying inadequate to the situation. The decision to leave the farm for river work in 1954 had not been a decision Leon made easily. The farm had been in the family since 1903, and he had grown up on it and had farmed it through his 20s and into his mid-30s with the specific attachment that farming the ground your father farmed and your grandfather cleared produces. In a man who has not known anything else, he had tried alternatives to leaving before leaving. He had tried to refinance the operating loan with the Defiance County Bank and had been offered terms that assumed a level of crop production that the 2 previous dry years had not produced and that the soil's depleted condition made unlikely to produce without input investments he could not fund. He had tried to restructure the farm's enterprise mix, adding hog finishing to the corn and soybean and wheat rotation that his father had run, and the hog operation had helped in 1953 before the hog market declined in 1954 in ways that the economics of a small hog operation absorbed more than the economics of a large one. He had calculated, repeatedly and carefully, what the farm needed to produce and what it could produce under the conditions that prevailed, and what the gap between those two numbers required in additional capital, and the gap had been consistently larger than what he could access from the sources available to him. The river work was available because his cousin, Martin, had been working the Mississippi barges since 1950 and had told Leon, during a visit in the summer of 1954, that the river company was hiring and that the pay was good and that a man who was strong and careful and reliable could build a bank account on the river in ways that farming could not build one in the current conditions. Leon had gone in September of 1954. He had intended to be away for 2 years. enough time to build the reserves that the farm's income could not produce, and to clear the remaining debt, and to return with something to work from. The river work paid better than any agricultural wage available in Northwest Ohio in 1954. And Leon was a capable worker who earned what the river paid, and who sent most of it back to August Feuerstein for the farm account, in the way that men who intend to return send their wages home. The 2 years had become 4, because the reserves took longer to build than 2 years produced, and because the work was available, and because returning to a farm that was still marginal in its income, when the work available elsewhere was not marginal, required a level of financial security that took until 1958 to reach. He had been in Baton Rouge in the fall of 1958 when the letter should have arrived. The address he had left with August Feuerstein for mail forwarding was a care of address at the River Company's Baton Rouge office, which was where his wages went and where he received correspondence. The county auditor's letter regarding the delinquent taxes on the Holthouse property in Paulding Township had been sent to the last address on the county's tax rolls, which was the farm address itself, where August Feuerstein was residing as caretaker, but where no forwarding arrangement with the county had been established. The specific chain of events that ran from the county auditor's mailing of the September 14th notice to the November 19th tax sale is worth following in detail, because the detail reveals how a process that is designed with protections built in can fail to protect when the procedural requirements are not properly observed. The county auditor's office had identified the Holthouse property as tax delinquent through the standard process of checking the tax rolls against the payment records, a process that was done annually in the spring, and that identified properties where the taxes for the previous year had not been paid by the statutory deadline. The Holthouse property appeared on the 1958 delinquent list for taxes going back to 1955. 4 years of accumulation that the audit process had not caught, or had caught and not acted on in the earlier years. The office had then followed the standard procedure for notifying property owners of tax delinquency and the potential for a tax sale, which was to send a notice to the address of record in the county's tax rolls. The address of record was the farm address, which was the address that had been on the tax rolls since Heinrich Holthouse had purchased the property in 1903, and that had not been updated when Leon left for the river in 1954, because neither Leon nor August had taken the step of notifying the county of a change in the property's management or the owner's mailing address. The failure to update the county's address of record was understandable from Leon's perspective, because Leon had not anticipated being away for 4 years and had not been thinking about the property tax notification process when he left. It was also understandable from August's perspective, because August was a caretaker rather than an owner, and the administrative management of the property's county records was not something he understood to be part of his role. The gap between what the county needed to know to properly notify the owner and what the county actually knew was the gap that the certified mail requirement was designed to close. If the notice had been sent by certified mail, the signature requirement would have revealed that the owner of record was not at the address of record, because the certified mail receipt would have come back signed by August Feuerstein rather than by Leon Holthouse, and that discrepancy would have prompted the county's notice procedure to seek a different address for the owner. The county had sent the notice by regular mail. No discrepancy was revealed. The notice reached the farm, where someone received it, and the process proceeded as if the owner had been notified. August had received the letter. He had recognized that it was from the county auditor's office, and that it concerned the property, and that it was addressed to Leon Holthouse, and he had set it aside with the intention of forwarding it to the Baton Rouge address once he had the envelope and the address together at the same moment, which he did not manage to do because he was 67 years old in 1958 and managing the farm alone, and the forwarding of a county letter slipped in the way that things slip for a man managing more than he can easily manage. The letter had described the property tax delinquency that had accumulated on the Holthouse farm from 1955 through 1958, a period during which the property had been generating insufficient income from the hay operation to cover the property taxes, and during which Leon's wage remittances had been applied to the reduction of the operating note and the maintenance of the property rather than to the tax obligation, which was an oversight in the accounting that neither Leon nor August had fully recognized until the letter arrived. The specific amount of the tax delinquency deserves a moment of attention, because $341.72 in 1958 was a significant amount to a farm operation that was generating minimal income, but it was not an amount that was beyond the reach of a man who had been earning river wages since 1954 and who had been sending most of those wages home against the farm's obligations. The reason the taxes had accumulated rather than been paid was that the accounting arrangement between Leon and August had applied the incoming wages to the operating note first, as Leon had intended, and to the maintenance of the property second, and had not explicitly reserved a portion for the property tax obligation because neither Leon nor August had been tracking the tax accrual year by year, and neither had received or processed the annual tax statements that the county was mailing to the farm address. The annual tax statements had been going to the farm since 1955. August had received them. They had been treated the way that mail addressed to Leon was treated in the absence of a clear forwarding procedure, which was to be set aside for Leon's attention when Leon returned. The setting aside had accumulated 4 years of annual tax statements in the same drawer, where the September 1958 notice ended up, and the drawer's contents had grown thick enough that the September 1958 notice, when it arrived, was simply another piece of official mail in a drawer of official mail, rather than an urgent notice requiring immediate action. If Leon had seen the annual tax statements as they arrived, he would have paid the taxes as they arrived. The amount due in any single year was manageable from the wages he was earning. It was only the 4-year accumulation, with penalties and interest, that had reached the level that the county treated as sufficient for a tax sale. The total delinquent tax, with penalties and interest, was $341.72 as of the date of the letter. The notice period provided by Ohio law for response to a tax delinquency notice was 60 days from the date of mailing, and the letter had been mailed September 14, 1958. The 60-day period expired November 14, 1958. The Paulding County Auditor's Office conducted the tax delinquency sale on November 19, 1958. The Holthouse farm was among the properties offered. It was bid by a man from Defiance named Willard Gross, who had been attending Paulding County tax sales for several years and who purchased tax delinquent properties as a business, buying the tax certificates and either redeeming the properties for the assessed value or holding them through the redemption period and taking title when the redemption period expired. Willard Gross purchased the tax certificate on the Holthouse farm for $412, which covered the delinquent taxes, penalties, and the county's sale costs. August Feuerstein had not known the sale was happening. He had forgotten the letter. The specific question of how Leon had not known about the 4-year tax delinquency before it reached the crisis point of a tax sale is one that the story requires to be answered honestly, because it is a question that reveals something about the way that farming operations can fail in their administrative management, even when the physical farming and the financial intentions are sound. Leon had known when he left for the river that the property taxes existed and were due annually. He had not known the specific amount because he had not looked at the tax statements carefully when he had been farming the place himself, because the taxes had been low enough relative to the farm's income that they had been paid automatically from the farm account without requiring close attention. When he left the arrangement for the river years in August's care, the conversation between them had focused on the operating loan, which was the obligation with the specific monthly payment and the specific due date and the specific consequence for non-payment that a bank-held note carried. The property taxes had been a background obligation, one that both of them assumed would be handled in the ordinary course of managing the farm account. The ordinary course had failed because August's management of the farm account had been adequate for the immediate obligations, the equipment, maintenance, and the fuel and the materials, but had not been adequate for the tax obligation, which did not send a monthly invoice to the operating account, but arrived once a year in a statement that went to the drawer. Neither Leon nor August had built a specific system for ensuring the property taxes were paid. The absence of that system was what the 4-year accumulation reflected. After the court proceeding, Leon built the system. The property taxes went first, before anything else. Every year, the day the statement arrived, Leon Holthouse had not known the sale was happening. He was working the river. The first Leon knew of any of it was December of 1958, when he returned to Paulding County with the intention of settling accounts and making plans for the following season. He drove to the farm in the truck he had bought in Louisiana and found August Feuerstein in the kitchen. And August told him, with the specific difficulty of a man who has been carrying knowledge he should not have been carrying alone, that there had been a letter, and that he had not forwarded it, and that the farm had been sold for taxes. Leon sat with this for a long moment. The specific manner in which Leon approached this conversation with August and the manner in which he approached the subsequent conversations with the county auditor's office and the courthouse is worth describing, because it was not the manner of a man who was angry, though anger would have been understandable, or the manner of a man who was looking for someone to blame, though the situation had a complicated attribution of responsibility. It was the manner of a man who had found himself in a specific situation that required a specific response, and who had calculated that the specific response required clear thinking and careful reading rather than the expression of the anger that clear thinking and careful reading would need to displace. He had sat with the news August had given him for about 10 minutes before he asked to see the letter. In that 10 minutes, he had done the specific mental work of moving from the emotional response, which was the response of a man who has just been told that the place where he grew up and where his grandfather had built something worth keeping has been sold while he was away, to the analytical response, which is the response of a man who understands that the emotional response does not solve the problem, and that solving the problem requires something else. He had been in difficult situations on the river that had required the same transition. Moments when something went wrong, and the response had to be immediate and clear rather than emotional and confused. And the practice of making that transition in less consequential situations had given him the capacity to make it when the situation was more consequential. He asked August to show him the letter. August found the letter in the drawer where he had put it in September, still unopened. He gave it to Leon. Leon read it. He asked August if anything else had come from the county about the property. August said a notice had come in November, after the sale, informing the owner of the tax sale and of the redemption rights available under Ohio law. The drawer that August opened was the kitchen junk drawer, the specific category of household storage that every farmhouse has, and that accumulates the items that do not have a specific place but that should not be thrown away. The rubber bands and the spare keys and the expired coupons and the cards from people who had come and gone and the letters that had arrived and been set aside for later attention. The Holthouse Farms version of this drawer was more official in its contents than most, because August had treated the farm's correspondence as something that should be preserved rather than discarded, even when he had not known what to do with it immediately. The annual tax statements going back to 1955 were in the drawer. The operating loan confirmation letters from the Defiance County Bank were in the drawer. Several pieces of correspondence from the County Agricultural Extension Office were in the drawer, and the September 1958 notice from the County Auditor's Office was in the drawer, still in its original envelope, still with the return address of the Paulding County Auditor visible in the upper left corner. August found the November notice underneath the September notice. It had arrived about a week after the tax sale and had described the sale, identified Willard Gross as the purchaser of the tax certificate, and described the redemption rights available to the owner of record during the one-year redemption period. He handed both envelopes to Leon. Leon looked at the envelopes before he opened them. He looked at the postage on both, the regular stamp affixed in the upper right corner, the postmark from the Paulding post office, the first-class routing that regular mail received. He looked for a certified mail sticker, the green and white label that certified mail carried, and for the certified mail tracking number that appeared on certified mail documents. Neither envelope had a certified mail sticker. Neither envelope had a tracking number. Leon opened the September notice and read it. He opened the November notice and read it. He read the November notice twice. Then he read it a third time, carefully, because there was a line he wanted to be certain he had read correctly. Leon asked to see that notice as well. August found it in the same drawer. Leon read it. The notice that August had received in November, after the sale had been conducted, was a document produced by the Paulding County Auditor's Office and printed on county letterhead, and it was in the category of legal notices that are produced in quantity and that contain standard language derived from the relevant Ohio Revised Code sections, language that was placed in the document not because someone had thought carefully about it for this specific case, but because it was the standard language used in all such notices. The line Leon was focused on was about the notice requirement for the sale itself. The notice quoted the Ohio Revised Code provision that required certified mail delivery of tax sale notices to property owners, and quoted it in the specific context of describing what the owner could assert if the notice had not been properly provided. It was, in other words, a notice that contained within it the information necessary to challenge the procedure by which the notice had been sent. He read it twice. Then he read it a third time, because there was a line in it that he wanted to be certain he was reading correctly, a line that his first two readings had found and that his third reading confirmed. The line concerned the notification requirement for tax sales under the Ohio Revised Code, specifically the requirement that notice of a pending tax sale be provided to the owner of record by certified mail, at the owner's last known address as it appeared in the records of the county auditor. Leon's address, as it appeared in the records of the county auditor, was the farm address. The letter had been sent to the farm address. August had received it, but the Ohio Revised Code provision, as the notice described it, required that notice be sent by certified mail, requiring the signature of the addressee or an authorized agent to confirm delivery. The letter August had received had not come by certified mail. It had come by regular mail, first class, with a standard postage stamp. August confirmed this from the envelope, which he had kept with the letter in the drawer. The notice of the November sale had been sent the same way. Regular mail, no certified mail receipt, no signature confirmation. Leon spent the rest of the Paulding County Public Library in 1958 had a reference section that included a copy of the Ohio Revised Code, which was the compiled statutes of the state of Ohio. Leon had not done legal research before, but he knew how to use an index. He found the Ohio Revised Code, tax sale provisions, and read them in full, not selectively but completely, reading the entire structure of the tax sale law, from the identification of delinquent properties, through the notice procedure, through the conduct of the sale, through the redemption rights. What he found was consistent with what the notice had described. The certified mail requirement was there, in the statute, in language that was specific about what certified mail meant and what it required, which was the signature of the addressee or an authorized agent acknowledging receipt. The requirement was not ambiguous. It was the method of notice that the legislature had determined was necessary to protect property owners from losing their land without actual knowledge of the impending sale. He also read the sections on the effect of a defective notice on the validity of a tax sale. A sale conducted without proper notice was voidable by the owner of record. The owner could bring a legal action to have the sale declared void and the property returned. He understood what he had. He spent the rest of that evening at the Paulding County Public Library, which was open until 8 o'clock and which had the Ohio Revised Code in its reference section. He was there when the library opened at 9 the following morning, and he was reading when the county courthouse opened at 8:30, and he walked to the courthouse at 8:31. He went to the county auditor's office. He asked to speak with the auditor. The auditor, a man named Harold Fishbach, who had been in the office for 11 years, came out to the counter and asked what he could help with. Leon said he was the owner of record for the Holthouse property in Paulding Township and that the property had been offered at a tax sale in November without proper notice to the owner under the Ohio Revised Code. Fishbach said the notice had been sent to the address of record. Leon said the Ohio Revised Code required certified mail for tax sale notices and that the notice had been sent by regular mail, and that a regular mail delivery to the address of record without signature confirmation did not satisfy the statutory notice requirement. Fishbach was quiet for a moment. He said he would need to look at the file. He went back to the records room. He was gone about 20 minutes. When he came back out, he had a file folder, and his expression was the expression of a man who has looked at something and found something he did not want to find. He said the notice of the pending sale had been sent by regular mail rather than certified mail. Leon said he was aware of that. He had the original envelope. Fishbach said that if the statutory notice requirement had not been satisfied, the sale might be subject to challenge. Leon said it was not might be subject to challenge. It was subject to challenge. He said the Ohio Revised Code was specific about the certified mail requirement, and that a sale conducted without proper notice to the owner of record was a sale that the owner of record could void. He said he wanted to know the procedure for challenging the sale. Fishbach told him the procedure, which involved filing a complaint with the Paulding County Common Pleas Court, citing the defective notice and requesting that the tax sale be declared void and the property returned to the owner of record. He also told Leon, with the candor of a man who understood what had gone wrong and who was not going to pretend otherwise, that the county would not contest a challenge based on the certified mail defect, because the defect was real and the Ohio Revised Code was what it was, and the county had made an error in the notice procedure that it could not defend. Leon filed the complaint the following week. The decision to file the complaint without a lawyer was a practical decision that Leon made from specific arithmetic rather than from any ideological position about legal representation. He had gone to see an attorney in Defiance on the morning after his courthouse visit, a man recommended by a neighbor as the most capable property attorney in the county, and the attorney had listened to Leon's description of the situation and had confirmed that the certified mail defect was a valid basis for challenging the tax sale. The attorney had also quoted his fee for representing Leon in the proceeding, which was $150 for the filing and appearance, with additional fees if the matter went to full trial, rather than being resolved on the motion. Leon had thanked him and gone home and spent the afternoon reading the Ohio Revised Code procedural sections on common pleas court filings, specifically the sections covering complaints and the required elements of a complaint in a civil action. The elements required were not complex. The complaint needed to identify the parties, describe the property, state the facts of the situation, identify the legal basis for the challenge, and request the relief sought. Leon had all of those elements in hand from his library research and his conversations with the county auditor's office. He spent 2 evenings writing the complaint in longhand, going through the required elements one by one, making certain that each element was present and that the language was as close as he could make it to the language of the statute, so that there would be no ambiguity about what he was asserting and on what basis. He showed the draft to the county auditor's office representative, which was an unusual thing to do, but which reflected Leon's practical understanding that the county was not going to contest the claim, and that showing them the draft before filing it would allow them to confirm that he had described the defect correctly. The county's representative confirmed that the complaint accurately described the certified mail defect. Leon filed it. He filed it himself, without an attorney, because he had read the Ohio Revised Code sections carefully enough to understand the specific claim he was making, and because the claim was simple enough that a man who could read the statute and describe the defect could file it without professional assistance. The complaint described the property, identified the defect in the notice procedure, cited the specific Ohio Revised Code section that established the certified mail requirement, and requested that the court declare the November tax sale void as to the Holthouse property and ordered the property returned to the owner of record. Willard Gross was not a villain in the story that the Paulding County Common Pleas Court was asked to resolve, and the way Judge Holthouse decided the case reflected this understanding. Gross had attended the tax sale in the ordinary way that he attended all tax sales, as a man conducting a legal business activity that the state of Ohio had explicitly created and regulated, and he had purchased the Holthouse tax certificate without any knowledge of or responsibility for the certified mail defect in the county's notice procedure. His attorney's argument in the hearing that the purchaser had acquired the certificate in good faith and in reliance on the county's conduct of the sale was a legally coherent argument that the court considered. The court had decided against it, not because it was unreasonable, but because the Ohio Revised Code's property protection rationale was more fundamental than the purchaser's reliance interest, and because the remedy for the purchaser was the refund of his purchase price from the tax sale fund, which made him whole on the transaction. What Gross had purchased at the tax sale was not a perfect title to the Holthouse farm. He had purchased a tax certificate, which was a right to the property, subject to the redemption rights of the owner and subject to any legal defects in the notice procedure. The risk that the certificate might be challenged was a risk inherent in the purchase of tax certificates, and Gross understood this risk in the general sense, though he had not specifically assessed the notice procedure for the Holthouse property before bidding. The outcome was fair to Gross in the sense that the refund of his purchase price put him in the position he would have been in if the tax certificate had not been offered, and fair to Leon in the sense that the invalidation of the defective notice procedure restored him to the position he would have been in if the county had followed the statute. Willard Gross, who had purchased the tax certificate and who received notice of the complaint through the court, appeared through his attorney at the hearing in January of 1959. His attorney argued that the purchaser had acquired the certificate in good faith, and in reliance on the county's conduct of the sale, and that voiding the certificate would cause harm to the purchaser who had done nothing wrong. The judge, a man named Common Pleas Judge Robert Holthouse, who had been on the bench for 7 years and who had a specific reputation in Paulding County for attention to the text of statutes, asked the county auditor's office whether the certified mail requirement had been satisfied. The county's representative said it had not been satisfied. Judge Holthouse said that the Ohio Revised Code's notice requirements for tax sales were procedural protections for property owners, and that the failure to satisfy those requirements invalidated the sale regardless of the good faith of the purchaser. He said the sale was void as to the Holthouse property. He ordered the county to refund the purchase price to Willard Gross from the tax sale fund. He ordered the property returned to Leon Holthouse as owner of record. He also noted in his decision that the county auditor's office had an obligation to satisfy the certified mail requirement, and that the failure to do so had caused the expense and inconvenience of the court proceeding, and that the office should ensure its procedures were corrected to prevent similar situations. The hearing had lasted about 45 minutes. The conversation after the hearing was brief, because the hearing itself had been brief, and because there was not much to add to what the hearing had produced, which was the farm returned to its owner by a judge who had read the same statute Leon had read and arrived at the same conclusion. Leon told August the sale had been voided and the property was his again. August said he had known about the letter since September and had not sent it, and had not told Leon when Leon returned in December, and he said he did not know how to say that in a way that was adequate. Leon said he understood. He said August was 67 years old and managing the place alone, and that the forwarding of a county letter was the kind of thing that got lost in the management of everything else. He said the more important thing was what had happened at the courthouse, which was that the county had made an error and that the error was correctable and had been corrected. He said if August had forwarded the letter in September, Leon would have paid the $341.72, and the sale would never have been conducted. He said if the county had sent the notice by certified mail, as the statute required, the discrepancy between the addressee and the signer would have prompted the county to look for Leon's actual address, and they would have found it through the river company or through the neighbor network. He said the failure was the county's failure, and that August's forgetting of the letter was an aggravating circumstance rather than the cause. August said he still felt responsible. Leon said he knew and that the feeling was appropriate, but that the farm was back, and that was what mattered. They had supper together that evening. The first supper Leon had eaten in the farmhouse kitchen since 1954, and August made the specific food that older German-American farmers in northwest Ohio made for occasions that warranted something more than ordinary cooking, which was pork roast with sauerkraut and the specific kind of potato dumplings that were the culinary inheritance of that community's origins. Leon drove back to the farm and told August what had happened. August said he was sorry about the letter. Leon said he understood. He said he wished August had forwarded it, but that the outcome would have been the same if he had been notified, because he would have paid the $341.72 from the wages he had in Baton Rouge without difficulty, and the sale would never have been conducted. He said the more important thing was that the county had made an error, and that the error had been recognized and corrected. August said he had not thought a man could go to the county courthouse and come out with his farm back. Leon said the law was the law. He said the county had to follow it the same as anyone else. The $341.72 in delinquent taxes was paid in full the following week from Leon's wages. There was no further tax delinquency on the property for the remainder of Leon's ownership. The farming years after the court proceeding were different from the farming years before Leon left for the river. Not because the farm or the ground had changed in any fundamental way, but because Leon had returned with something he had not had when he left, which was the specific financial security of a man who had worked for years and saved most of what he earned, and who was returning to a farm he owned without any operating debt attached to it. The $341 in delinquent taxes had been paid within the week of the court decision. The operating note that had been the reason for the river years was long since paid. Leon had come back to a farm that was free and clear, that had been kept in reasonable condition by August Feuerstein's stewardship, and that required capital investment in equipment and fertility, rather than the kind of debt restructuring that had complicated the operation in the early 1950s. He farmed it with the specific attention of a man who had been away and who had come back having learned something from the being away, which was the value of a farm that you own without anyone else having a claim on it, and the importance of not allowing the tax obligation to accumulate in ways that create the vulnerability that the 1958 situation had exploited. He paid his property taxes in January and July of every year from 1959 forward, the day the statements came, before anything else was paid from the farm account. This was not a formal rule he had adopted, but a practice that had become automatic from the specific knowledge of what the failure to pay the taxes had produced when he had let the obligation accumulate unknowingly. August Feuerstein continued to help on the place through the early 1960s, until his health prevented it, and Leon helped August in return in the way that farming neighbors who are in each other's debt help each other, without accounting and without expectation of precise reciprocity. Because some debts between neighbors are not the kind that lend themselves to precise accounting. He farmed the 112 acres from 1959 through 1982, when he sold the property to a neighbor's son and retired to the farmhouse with his wife of 22 years, a woman he had met in Paulding in 1960 and married that same year. The sale was on his terms, at a price he set, on a schedule he chose, to a buyer he selected. He had had that choice because he had read the line in the notice that August had kept in the drawer, and had recognized what it meant, and had gone to the library that evening, and had gone to the courthouse in the morning. What Leon Holthouse had done in the 2 weeks between reading the notice in August Feuerstein's kitchen in December and the filing of the complaint at the courthouse was not what most people in Paulding County in 1958 would have expected a farmer who had been working a river barge to do. It was systematic, methodical, careful work, the work of someone who understood that the situation required a specific kind of attention and who provided that attention without the assistance of professional advisors. He had read the statute. He had read it completely and in context, not selectively and not from a summary. He had identified the specific provision that applied to his situation and had verified that the provision meant what he thought it meant by reading the sections around it and by confirming his interpretation with the county official who was on the other side of the issue. He had written the complaint in the language of the statute rather than in his own words, because the language of the statute was the language the court would use to evaluate the claim, and using the same language reduced the risk of ambiguity. He had filed it himself rather than paying a lawyer to file it because the claim was simple enough that a careful reading of the procedural requirements was sufficient preparation, and because the money saved was money that should go to the tax obligation that had created the situation. The judge had decided the case in his favor in 45 minutes. None of what Leon had done required legal training or professional experience. It required the willingness to read carefully, to ask questions of the relevant officials, and to write down what the reading and the questions had produced in a form that the court could act on. These were things a farmer who had worked a river barge for 4 years could do. He had done them. He had never thought of himself as a man who understood the law. He was a farmer who had worked a river and who could read. Reading the statute carefully had been sufficient. The farm had not been lost because one line in a government notice said the county had missed a step, and the county had, in fact, missed a step. And a step missed in a legal procedure is the difference between a valid action and an invalid one. The hearing before Judge Holthouse in January of 1959 lasted 45 minutes, but the preparation for the hearing had taken Leon the better part of 3 weeks from the December evening when he had read the notices in August's kitchen. In those 3 weeks, he had done the library research, and the courthouse research, and the complaint drafting, and the filing. And he had also made the trip to see the attorney in defiance, and had made the decision to file himself after hearing the attorney's fee. The 45 minutes in the courtroom was, in this sense, the visible portion of a much longer process, and the visible portion was smooth, because the longer process had been done thoroughly. Judge Holthouse had not needed to ask Leon many questions because the complaint had described the situation clearly, and the county's representative had confirmed the certified mail defect without being pressed. The only real legal argument in the hearing was Willard Gross's attorney's argument about the good faith purchaser, and that argument had been resolved by the judge's straightforward application of the statute, which placed the owner's right to notice above the purchaser's reliance on the county's conduct of the sale. Leon had understood, before the hearing, that the argument would go this way. The statute was clear that a defective notice invalidated the sale, and the county had confirmed the defect. The purchaser's good faith was relevant to the remedy, which was the refund of his purchase price, but not to the outcome on the fundamental question of whether the sale was valid. He had not been surprised by the decision. He had been certain of the outcome before he walked into the courtroom. The certainty had come from reading the statute carefully enough to understand what it said, and what it required, and what happened when what it required had not been done. Reading carefully, that was the whole of the legal strategy. That was enough. The story of the Holthouse farm and the certified mail defect was told in Paulding County for years after the January 1959 hearing, not because it was a dramatic story in the sense of courtroom drama or legal maneuvering, but because it was a specific and legible story about a man who read a document carefully and found in the document the information he needed to recover something that had been taken from him by an error in the process. The story traveled through the farming community in the way that useful information travels through farming communities, from neighbor to neighbor, and at the cope and at the elevator, told not as a tale of triumph over the government, but as a practical piece of information about what the Ohio Revised Code's certified mail requirement meant and what a property owner's rights were if the county failed to satisfy it. Several men who heard the story had their own questions about the property tax process and went to check their tax payment status with the county auditor's office in the months after the story circulated. At least 2 of them discovered small delinquencies they had not been aware of and paid them before they reached the level that triggered a tax sale notice, which was a practical benefit of the story's circulation that Leon had not anticipated when he did not ask Judge Holthouse to keep the decision quiet. The story's most useful characteristic was its specificity. It was not a general story about knowing your rights or fighting City Hall. It was a specific story about a specific statutory requirement that had a specific consequence when it was not satisfied, and that specificity made it useful information rather than inspirational narrative. Leon had not intended to provide useful information to the county when he walked into the auditor's office. He had intended to get his farm back. The 2 outcomes had turned out to be the same action. One line, $341.72, a certified mail requirement that had not been certified. The farm was his. It had always been his. The county had simply forgotten to follow the procedure that said so. The courthouse visit on the morning after the library evening was the first time Leon had been inside a county courthouse on any kind of official business. He had been in the county recorder's office twice when property transactions required it, and he had been in the probate court once when his father Carl had died in 1949 and the estate had needed to be settled. But he had not been in the auditor's office, and he had not spoken to the auditor in the course of managing the farm. He had stood at the counter and waited while the woman behind the counter went to get fishbock, and he had collected his thoughts in the waiting, going through the specific points he wanted to make in the order he wanted to make them, not rehearsing a speech, but organizing the information so that the first thing he said would be clear enough that Fishbock would understand what the conversation was about. He had been working on river barges for 4 years. The river required clarity and conciseness in communication among men who were doing complex work in conditions that did not allow for ambiguity, and the habit of clarity and conciseness had carried over into the courthouse the same way it carried over into everything else. He said what he had come to say. Fishbock went to look at the file. The file confirmed what Leon had said. That was the courthouse visit. It took about 30 minutes. The farm came back from 30 minutes at the courthouse after a library evening, and the willingness to read a document that August had kept in a drawer for 3 months. Leon Holthouse sold the Holthouse farm in 1982 to a neighbor's son named Gerald Heitkamp, who had been farming adjacent ground and who wanted to expand his operation. The price was fair by 1982 standards for Northwest Ohio tile-drained farmland, and the sale was conducted with a clean title. The same clean title that the Holthouse family had maintained since Heinrich had bought the 80 acres in 1903. The certified mail story had circulated in Paulding County for long enough by 1982 that Gerald Heitkamp knew it before he completed the purchase, had heard it told by his own father, who had heard it from a neighbor who had been at the corp the week after the January 1959 hearing when Leon had told someone who had told someone else. Gerald said, in the closing conversation at the title company in Defiance, where the papers were signed, that the story had stayed with him since he had first heard it as a younger man. Leon said it was not a story he had planned. He had planned to come home and pay his taxes and farm his ground, and the situation had required something other than that, and he had done what the situation required. Gerald said he thought most people in the same situation would not have done what Leon had done, would not have read the notices carefully enough to find the certified mail line, or would have found it and not known what to do with it, or would have known what it meant and been too uncertain about the courthouse to act on it. Leon said he had not known what to do with it immediately when he found it. He had gone to the library that night to find out what to do with it. Gerald said that was the thing. Going to the library. Leon said that was exactly the thing. Reading the statute carefully enough to understand what it said. Going to find out what you needed to know before you needed to know it for the first time in the courtroom. He had done that. The farm had come back. He had farmed it for 23 more years. He had sold it on his terms. The line in the notice had been one line. The county had written it there to describe what property owners were entitled to under Ohio law. Leon had read it. That was the whole of it. That was enough. There is a broader lesson in the Leon Holthouse story that applies beyond the specific circumstances of a 1958 tax sale in Paulding County, Ohio, and it is worth stating because it is the lesson that makes the story useful to people who are not and will never be involved in a tax delinquency proceeding. The lesson is about the relationship between reading carefully and having power over your own situation. Leon Holthouse was a farmer who had worked a river barge for 4 years. He had not gone to law school. He had not worked in a government office. He had not previously had any experience with legal proceedings of any kind. What he had was the willingness to read a document carefully when the document mattered, and the follow-through to go to the library and find what he needed to understand what the careful reading had found, and the further follow-through to convert what he had learned into the specific action the situation required. The specific action was a complaint filed with the county court, citing a statute and describing a defect. It was not a dramatic legal maneuver. It was the application of what the document said to the situation the document described, done by the person most affected by the situation rather than delegated to a professional. The county had not expected this. Fishbox's expression when he came out of the records room after 20 minutes was the expression of a man who had expected to be dealing with a grieving property owner, looking for sympathy, and had found instead a man who had read the statute and who knew specifically what had gone wrong and what the law said should happen as a result. The farm came back because Leon had read the document. The document had been sent by the county. The county had written in the document, in the standard language derived from the Ohio Revised Code, the specific requirement that the county had failed to satisfy. Leon had read it. That is the lesson. Documents contain information. The information is available to anyone who reads carefully enough to find it. Reading it is the work. The work was done. The farm came back.